You know.
Raghunandan.
Perfect.
Thank you. On behalf of the State Advocate 9 from the Office of the DPP, Johannesburg, for accused number 1, Mr. Extian, and for accused number 2, Advocate 2. May I approach the bench?
Mm-hmm.
You were informed earlier this morning that the matter was transferred from court number 1 for purposes of a bail application. I believe before we proceed with the formalities, the defense wishes to address the court.
Yes, you may proceed.
Morning, Bishop.
Into the record, thank you, Counsel.
I confirm my appearance on behalf of accused 1. I'm also the instructing attorney in the matter of accused 2 for Advocate Krill.
Okay, thank you. Are you on record here? It's Mr.
I don't think I've appeared the last time. I think Advocate Krill was the only one who appeared.
Yes, for accused 2, it said. The record reflects.
Yeah, but he was previously, I think, on the first appearance for accused 1 as well, on my instructions.
Okay, you are Mr.
Extian.
Are you? Yes, I have that. Are you representing accused 2 as well?
I'm the instructing attorney. Advocate Krill will represent her during the bail application.
All right. So,
But it's on my instructions, Bishop.
okay.
Yes, completely. That's indeed correct. I think we want to be careful at this stage. There may be a conflict of interest, and we decided in the interest of justice that we, at this stage, separate between the two, and then, if necessary, and if there is no conflict, we can always take the matter further. But it's the same instructing firm that's instruct us both.
So what is the position now? Are we proceeding? Who's on record for accused 1? Mr. X?
Myself, correct, Bishop.
All right. So for accused 2, you would
That
remain.
is myself, Bishop.
All right. So we're great. Thank you.
Thank you, Bishop.
That clarifies it.
Thank you, Bishop. There is a dispute regarding the schedule. The state wants to proceed with this bail application, Your Bishop. They have indicated that it would resort under Schedule 5. We will place that in dispute, as the fact to say that somebody has been charged for money laundering, clearly, no court can accept that. We know the POCO Act is clear, and that the state must then reflect under which section of the POCO Act they want to charge the accused. Just mere to come to court and say they are charged with these child pornography charges, which are clearly, I think it's not even disputed with the state, that resorts under Schedule 1. And then they only, for the reason be adding the charge of money laundering, say now it must resort under Schedule 5. Now, you wish it clearly. Just to say money laundering is difficult. They must come with facts and then say under which section of the POCO Act the charge gets accused, so that he can answer to that. The POCO Act is wide. There is several sections under which they can charge him. We still, to date, do not know. All they said to us is charge of money laundering. Now, you said that will be clearly not in the interest of justice to then say this matter must resort under Schedule 5. The state must either decide to play open cards, give evidence to this court to make a decision regarding that, whether it will be resort under Schedule 5, or, like the Act say, they must bring a certificate from the DPP to the court and say they intend to charge him under Schedule 5, and here's a certificate from the DPP.
Anything further?
That's just on that aspect. I think my learned friend for accused 2 will also address the point.
Yes, completely, Your Worship. I confirm my learned colleague has placed on record, Your Worship, and I can state I was present during the arrest of accused number 2, and I requested the states on what basis are you charging her? And they indicated that we'll hear that in court. If I refer, Your Worship, to matter S versus Kok, 2003, Volume 2, SACR, page 5. Matter of Supreme Court of Appeal, and this basically locus classicus with regard to Schedule 5 offences. And
Do you have a hard copy of that?
Excuse me, Your Worship?
Do you have the hard copy of that case with you?
I do not have a copy, Worship, but I'll make one available later during the day to you, Worship. And that was a very similar matter. It was indecent assault. The applicant to that bail application was a teacher, and there were a lot of minor children involved. He was charged on the basis of the Schedule 5 offence. And on the appeal, the SCI held, the evidence of the investigating officer did not suggest unlawful application of force in a broad sense or threat to inflict such force. There was accordingly no justification for the magistrate indiscriminately to have treated the litany of acts chronicled by the investigating officer as evidence of Schedule 5 offences. The courts have found no fault with the magistrate's summary of the case against the appellant. The learned judge too, perhaps because it was subject to the same misapprehension, made no attempt to identify possible instances of assault among the welter of allegations of improper conduct. It may be that Section 40 of the Sexual Offences Act 22 of 1957 was the appropriate result of certain of the acts described in evidence, but such an offence is not included in the 5th schedule. Bishop, this is exactly the same. There are numerous allegations made of the photographs or, I don't know, the child pornography, let's be straight. That was the possession of the applicant. However, there's no indication to say that what the basis of the Schedule 5 is. The court then held, the magistrate should, I think, have been conscious of the prejudice to the appellant in allowing evidence on the hit and miss approach followed by the state. She has required the prosecutor to confine her evidence to the offences on which she relied for an invocation. I do apologize, Your Worship. She should require the prosecutor to confine her evidence to the offences on which she relied for invocation of Section 6011B, or if the prosecutor intended in an alternative to contend also for the refusal of bail without reliance on a scheduled offence, which was an option not raised, and was certain from the precisely which acts of the appellant the state contended for as constituting Schedule 5 offences. Which is my respectful submission that, especially with the second applicant in this matter, we do not know on what acts the state was allowed to allege that firstly she was involved with the child porn, and secondly why she laundered money. My little colleague will probably later address Your Worship once we get to that stage, that money laundering has got a specific requirement. If you enter a shop and you steal a loaf of bread, you walk out, is that going to charge you with theft as well as money laundering because you received the proceeds of crime? Under these circumstances, there's a very specific and limited legal application of money laundering. We do not know upon which section the state relies, on what basis will change this from possession, maybe manufacturing or even distribution of child pornography, to a Schedule 5 offence of money laundering. And it's therefore a respectful submission, Your Worship, that there is a duty in the court to inquire from the state before the provisions of Section 6011B is triggered, exactly what the basis and the factual allegations are, which would trigger the severe prejudice to the applicants in this matter. Thank you, Worship.
Yes,
Your Worship, before that, can I ask if the accused can be seated?
Yes, thank you, of course.
Before I proceed to address the point regarding the schedules that we will be charging the accused for, there has been annexes attached to this one indicating that the accused will be charged with contravention of Section 5 of Act 121 of 1998. That would be assisting another to benefit from proceeds of unlawful activities. Money laundering in itself, the offence is Section number 4. The naming of Section 4 is money laundering, so one would I was under the impression that my learned friends would have understood that to mean the contravention of Section 4. We will further also be adding charges, counts 6, contravention of Section 6, that is the acquisition, possession or use of proceeds of unlawful activities. Your Worship, before we proceed with that, however, the defence for accused number 2, Mr. Creel addressed the court regarding the bail application of accused number 2. At this point in time, the state will not be in the position to proceed with the application against accused number 2, which would be the applicant number 2, as we were only furnished with an address this morning. That address has not yet been verified. Your Worship is well aware that we have been in court since early this morning. It would have been impossible to verify the address. So I am not sure whether the defence intends to proceed with the actual application of applicant number 2 then, as it would be, if we make it clarity regarding that before I address the court regarding the money laundering and the schedule.
Esther, just before you be seated, how long will it take to verify the address?
Well, I've not had a look at the address and where it's located. I will not mention the address as it has been agreed upon by the defence as well as the state. So I would have to have a look at the address, Your Worship, and then be able to ask the investigating officer how long it's taking to do.
Thank you.
Your
Applicant,
Worship, maybe if you can place, Your Worship, in the picture of the reason for the address being given at such short notice. Both accused wanted to live together in a rental property. The arrest of accused number one basically turned into a media circus and everybody went crazy. The effect was that the landlord with immediate effect terminated the lease agreement of accused number 1 and 2. We then arranged, Your Worship, they were still innocent, they were not being convicted of anything, but it was a summarily done. We then arranged that she will stay with one family member, and after parents, Your Worship, exactly the same frenzy, and they became concerned that, due to various factors, Your Worship, that they cannot allow her to stay there if their address will be mentioned in court. We then arranged for a third family member in Gauteng with who the second accused or the second applicant will then reside. So this is the reason. It's not as if they were trying ducking, diving with the address, Your Worship. We found ourselves in a position that due to the circumstances of this specific case, it became impossible to live at the residences that they had. But I totally agree there was not sufficient time to confirm this address. It was given to them this morning. I only ascertained that last night. And under these circumstances, Your Worship, we would not oppose the matter being postponed. Whatever is important is if this should turn from a Schedule 5 to Schedule 1 offence, or at least an unscheduled offence, then the onus stays, and if the Malona colleague, and I'll address Your Worship later on that if it's necessary, then there's the onus in the states to provide reasons to Your Worship why the interest of justice requires the continued incarceration of the accused, whether at the same address or any other one. So, for purposes of this application, why I address Your Worship with regard to the schedule, it may have an impact on whether the accused, the second applicant, should be detained pending a further bail application. Thank you, Your Worship.
State, it appears there's not opposing the postponement for the verification of the address of accused 2. The council appears not to oppose it.
Yes. So there will be, we are in agreement that that application might be postponed. The investigating officer will need 2 days to verify the address that has been supplied. Unfortunately, tomorrow and Thursday he is not available. He is attending matters in other courts. So, and the state will also know I will not be available for the remainder of this week. We will have to arrange a date early during the course of next week. For the application. I'm not sure whether the court would be amenable to this kind.
Your Worship, my learned colleague became involved only this morning. There was a prosecutor dealing with this matter. For the whole of this, from the 3rd until the 7th, I am in court already. I'm available on Friday the 31st. May we not arrange with anybody else, just for purpose of the bail application, to deal with the matter then? To keep the applicant in custody for another 2 weeks will not be justified under these circumstances, Your Worship.
If the court takes into consideration that if Miguel is not available, I am not available on Friday. It is 1 day that I am not available. I am available the remainder of next week. It would not be fair on me to saddle one of my colleagues with this matter at this stage.
Yeah, the court agrees
So
with
it
you.
would be
The court agrees with you, State. I think the matter can be rolled till Monday, or postponed till Monday.
Yes, good, Your Worship. I will make arrangements for somebody else that should deal with the matter. If I may be excused on next week, Monday, that'll be the...
Are you not available on Monday?
Your Worship, for the whole of next week, I'm not available. I'm available today, tomorrow, and Friday. The 30th, Thursday this week, I can make myself available, but it's been a long-lasting trial that's going on for years, the Specialised Commercial Crime Unit, Your Worship, so I will not be able to attend in next week. But can we postpone, if Monday is the soonest possible date? If I cannot make arrangements that I personally excuse myself from that matter, then I will attend. Otherwise, I will arrange for somebody else to attend to this matter.
That's in order. That's in order. Report.
You have seen that I'm the instructing attorney in the matter. I think he just needed to get my input here first. I know that on Tuesday I would be able, as Monday I'm unfortunately, Friday and Monday in Cape Town with matters there. For Friday I've got a matter there and Monday as well. So I'll be available on Tuesday. And if it needs to be that I need to proceed without counsel briefed and client is satisfied that I proceed, I will proceed then on that basis.
Okay.
Unfortunately, I am tasked with the firm Mr. XTN represents in the High Court on a trafficking in persons matter. I'm sure he will be informed by his colleagues. It is sentencing in that matter. I cannot be here on the 4th. I am available on the 3rd. Fortunately, Mr. Khalil already indicated he will make arrangements. The firm is, I'm sure that there is someone else from the firm that could be this officer while Mr. Khalil is not.
When are you available next?
I am available on the 3rd.
That's the third
I'm
day.
also available on the 5th, the 6th, and the 7th of next week. The 4th, I have to attend to a sentencing matter in the High Court.
So it either looks the 3rd or the 5th.
Correct.
3rd or the 5th. Gentlemen?
Chief, under circumstances, I mean, if we then can roll it to the 3rd, we will make provisions that somebody will attend to it. If I need to brief another council, I will brief it and then happily continue then on the 3rd.
All right. So, are you proceeding with the bail application
Yes, Your Worship, I want to proceed
for your client?
for my client, definitely, Your Worship.
Estate?
The defense indicated that they will require a certificate from the Director of Public Prosecutions in order to indicate the
Schedule.
schedule. We have no objection in providing them with that certificate. Unfortunately, we will only be able to do that. Well, we will not be able to do that today. We were not aware until this morning that they were going to oppose or dispute the schedule. The state has in its possession evidence of a minimum of 24 counts of money laundering already, where certain funds is moving in, and I apologize from addressing the court from the bar, but I've now been placed in a situation where I have to address from the bar. The state has, in its very short time that it has had the opportunity to investigate this matter with the financial aspects involved, found a minimum of 24 counts of money laundering, of monies moving in and out of the accounts of applicant number 1.
Okay. Mr. Dixon?
Thank you, Your Worship. Your Worship, based on that, as my learned friend just now placed on record, to say this is what they rely on, I can refer the court to the matter of S versus van der Linde, 2016, volume 2, SACR 377, and this was in GJ, so it was in the local division Johannesburg. Now, Your Worship, in this matter, the learned judge also found that the state, the accused were charged as follows: prevention of crime offences, prevention of Section 4 of the Prevention of Organised Crime Act 121 of 1998, money laundering. Furthermore, what constitutes fraudulent VAT refunds deposited into business accounts and then immediately withdrawn by means of cash cheques or deposit into another business account, where no attempt at concealment, money laundering, not proven. So for the state now to say that's the reason that they rely on to say it's money laundering, it's clearly a case law from their own division that says whether money was being used or transferred from one account to another account does not constitute money laundering. Clearly not money laundering. And it went further here, and it was held that to say the court found the accused guilty on all counts of fraud, forgery, and uttering, and then considered the issue of the money laundering counts, which involved a deposit into an account of an entity of which the accused was the sole member. 2060 checks, which were the proceeds of the fraudulent tax refunds, were paid into this account. The state contended that the cash checks issued from the account had the inherent effect of concealing property. It was submitted that the drawing of the cash checks disguised the origin of the money, and once deposited into the account, the proceeds commingled with other legitimate funds and became difficult to trace. It accordingly legitimized those proceeds and constitute money laundering, as envisaged by POCA.
Mr. Eckstein, I'm going to stop you. I'm not into the
Yes.
merits into the bail application yet.
Yeah.
What the state has suggested, that you said that there's no certificate from the DPP regarding the schedule. I do not want to make a finding on the schedule from what she's saying and what you said. I will request that a certificate be obtained from them.
Yeah, Your Worship, I just want to place on record that this was placed on record on the first appearance of the accused, that this will be in dispute. So they had more than 7 days to get this certificate. To say today they didn't know about that's in dispute is clearly wrong. Advocate Creel is the person who represented the accused one, and he was clear the instructions to him to say if they want to bring it out under Schedule 5, it must be disputed. And he did on that day, according to my instructions.
Was it placed on record, your dispute? When was that?
Your Worship, the main reason for the states, I gave a very similar address at that stage, and the state indicated that they would want to investigate whether it's a Schedule 5, whether it's money laundering or not. And that is the reason the matter was postponed to today specifically to investigate whether it's money laundering. So the issue was definitely, is money laundering in dispute? And under these circumstances, is the accused going to be charged with money laundering? Because the effect, and it's words by the regional magistrate, was that it can go both ways, because if the state does the investigation and it's not money laundering, we will proceed not on the basis of a scheduled offence. So this was actually the reason for the postponement up till today.
I have to respectfully disagree. When you was informed that I only had received instructions to come and deal with this matter yesterday. The initial request was in terms of section 50, subsection 6, paragraph B, for verification of assets and the accused's address. At that stage already, we were informed that there's a possibility that applicant number 1 might not return to the address that they had supplied. So there was multiple reasons for the request. Mr. Creel can confirm that this morning when he informed me that they will be disputing the schedule, I was taken aback. I was not aware of that. I'm an officer of this court. I will not inform the court of things that if I was not aware of the schedule being in dispute. Mr. Colombia can confirm. But I do think it is pertinent at this point to request that this matter be postponed for the Director of Public Prosecutions to authorize the schedule. If the Director is of the opinion, Your Worship, that this matter should indeed resort under Schedule 5. And that would then be handed to the court as prima facie.
Will next week be sufficient time?
Well, Your Worship, seeing that we are already here on the 3rd of February for applicant number 2, in order to keep everything together, I would suggest for purposes of both qualifications that we proceed on the 3rd of February. When we are not doing things in a piecemeal basis, which is not in the interest of either the state or the
Any final submissions before the court makes a ruling?
I would say it is clearly not in the interest of justice to afford the state the postponement to obtain now a certificate which they knew from the first appearance was in dispute. They could have been ready. Why it's going to take them days to get the certificate is also unclear.
Mr. Eckstein, the advocate has informed the court she wasn't aware until this morning.
Your Worship, it's clear because she only came on record now this morning for the first time. But surely her learned friend, who dealt with the matter previously, she inquired from them, could have informed her to say, listen, if we're going to do it under Schedule 5, remember there was a dispute regarding this, and we need to be ready.
When was the matter in court previously?
The 19th of January.
Was it noted on record on the schedule here?
I was not present, Your Worship. Unfortunately, I cannot assist the court on that aspect.
Thank you. Anything further?
Nothing further. Thank you, Worship.
Very well. Court ruling. The matter will be postponed to the 3rd of February. Back to this court. It is for the continuation, for the bail application, and for investigating officer to verify the address of accused number 2, for the state to provide the certificate from the Director of Public Prosecutions. Accused 1 and 2, please stand up. Okay, did you hear? The matter is postponed to the 3rd of February. Back to this court. You both remain in custody until then. Thank you.
You should, before they stand up, can I just clarify one aspect regarding the address of accused 1? I know it's an address out of the province. I don't want to say where it is, as per its agreement, that the address will not be disclosed due to safety reasons for the family and everybody. But if that address has been confirmed, and if not, that it also be confirmed before Monday's proceedings.
State, do you want to reply to that?
We have the address that is outside of province. We will do our utmost to see that it is indeed verified. We have unfortunately had time constraints in getting authorization for the members of the SAPS to investigate outside of province.
Okay, so can I add that to verify accused 1's address as well?
That is correct.
Very well then, accused 1 and 2, you will remain in custody. Thank you. You may stand down. You're excused.
Is it please the court, Your Worship?